like to welcome you to the JCAR General Membership Meeting and to thank you all for attending. Appreciate John spending his time also to give us information about our new forms that we're all going to have to tackle. So before we get started, we'd like to pledge allegiance to the flag, please. So let's get started. Let's pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you guys so much. John is with us today. Just a little bio on John. John joined Martin and Guilford after founding his own firm and clerking for several of the judges in the North Carolina Court of Appeals. He spent his first 8 years in the firm practicing trial and appellate litigation. He now uses that valuable background to draft forms and give advice and guidance to brokers, real estate firms, local boards of realtors, and the North Carolina Association of Realtors. In his free time, John enjoys coaching and playing soccer, cycling, reading novels, and spending time with his family. He's also the former mayor of Clemmons, North Carolina. So let's welcome John, and thank you so much, John, for giving us your time today.
Thank you very much. Appreciate it, Tim. We're going to have a great time today, you guys. I got my favorite tie on. We got all sorts of interesting things to talk about with these forms. You guys love all these forms changes, so all you need is like a little bit of context and help with figuring them out. And yeah, no, I know like half of that is true, but that's okay. We are going to have fun today, though. It's at least going to be interesting. I can promise you that. So I'm going to start sharing my screen here. And what we're going to start with is actually the new website for NC Realtors. If you've not been on it yet, you need to get on there. And the reason is because it is a significant upgrade. Now, mind you, any of you that have dealt with a website before, when you roll out a new website, which this one came out like 2 weeks ago or so, anytime you roll out a new website, it takes some time to work out the bugs. There's always something. You get to blame it all on your IT guy, and it's never your fault. So it's great as far as that goes. And that's definitely true in this case. I can tell you that NC Realtor staff has worked really, really hard on the content side of this to improve it and make it a lot better. But also, not to be too harsh on the IT guys, the site itself functions much better. Number one being, this is all over the website. There are these search term bars. You can just type in what you need. It's likely going to come up. I've been playing around with it the last couple of weeks. It is extremely effective. It's about 1 billion times better than what we had before. So interestingly about this website, just so you know, we're going to go through it a little bit today, just kind of how to navigate it. But just so you know, it may look different on your computer. This is a dynamic website, which means that it's going to look different on your phone, on a smaller screen, which today, I've got a laptop that's like 13 inches. And then, on my big screen on my laptop, it looks even different. The reason is it optimizes your experience for each kind of screen. And it's supposed to do that. And once you get used to it, it's definitely, in my mind anyway, preferable. In any event, all right, so here we are. And what you can do is, you can navigate up here. Some of you are going to have this navigation in other parts. It'll be all across the top. But if you go up here and navigate, go to legal and ethics. We're right here on legal and ethics. The risk management library, it's a brand new feature of the website. It is something that we're still updating the content on because this has been a project that has been slowly rolling out for about, 2 or 3 years. But the risk management tools and the risk management library is a whole series of, they're not Q&As, they're actually additional articles that go, help you with risk management with filling out Form 2T is the topic we have on there right now. I wouldn't get too far into it yet. There's a bunch of those articles we got to actually, we are in the process of redoing because some of the articles are 2 to 3 years old. And as you can see today, especially with respect to the forms changes that are coming out this year, there needs to be a lot of changes to those articles to make sure that they're current. Some of the information is still going to be great. If you want to go look around in the risk management library and look at some of those articles are going to be still very relevant, but just make sure that you're kind of, reading them with an eye toward, okay, well, how does that really square with the forms changes that have come out over the last couple of years? In any event, I'm going to go through this next part, and if you pay attention to this next part coming up, then you can tune out pretty much for the rest of the day, I think. But don't do that. But you can. You have my permission. You won't hurt my feelings. I can't even see you, so I don't know. I'm not the police. It's going to get you in trouble if you're not paying attention. In any event, you click on Q&A. This will take you, if you're familiar with illegal Q&As, this will take you to what those are. Those are the ones we release every Monday. Those come from me and my law partners in my office. And if you scroll down a little bit, you can see that the Q&As are ordered by date. So the date they came out, they're right here. It shows you when they came out. You can also sort it by alphabetical if you'd rather do that by clicking this up here. And as I told you earlier, the search bar is right here if you would rather use that. The search bar is very effective, by the way. It'll search the entire article because instead of each one of these being a PDF, which is how they used to be, now they're actually in the website. We'll see that in a minute. But if you scroll down in the Q&A part of the website, and right here, just a couple of weeks ago, or I guess it was May. Oh man, right before, at the end of May here, we put all three of these summaries out for commercial, residential, and property management. Okay. So if you click on this right here, I've already got it open. So I'm going to move over here a little bit. Oops. There it is again. It comes up with this. And what this is a summary of all the forms changes. It's everything I'm going to be going over today. If you click on these hyperlinks, you can see that you can click on these, which are the actual forms. It'll take you over to this, which is the actual form with the highlighted changes. And that is how we're going to be going through these today. It's kind of just how I prefer to do it. I don't know about you guys, but it just helps to be able to visualize the highlighting and the strike throughs and things like that. So without further ado, let's go into 2T and talk about some of these changes that are in 2T. This has not truly been deleted. Really, it's just been reformatted down here so that we could add this part here. The property will or will not include is the second line right here. Will or will not include an off-site and or separate septic lot, boat slip, garage, parking space, or storage unit. So if you got one of those things, check this box, and then it says, make sure attach the additional provisions addendum if you got one of these things. All right. So let's move over to the additional provision addendum and just cover that real quick while we're here. Okay. Any additional provisions addendum. This is going to come up a little bit later in Form 2T, and I'm not going to go into it in depth, but basically there's a lot of changes to clarify when you're selling rental property, especially with the tenant inside, what the landlord / seller's obligations are. It's nothing too significant. It's really just to bring clarity. And if you got a difficult seller landlord, to really kind of, grab them by the ear and pull them along where they need to go. You scroll down here, there's a brand new paragraph 7 on the additional provisions addendum. And you can see these check boxes here where if you have one of these things, you can say whether it's deeded, leased, seller owned, HOA owned. Depending on what it is, it could be one or most or several of those things on the check boxes. I would say this, do the best that you can with the check boxes. The important part of these blanks, make sure you describe in these blanks really well, don't skimp on it. Make sure it's described really well. And then that way, anything else is really going to take care of itself, even if you don't fill it out perfectly, because right here, this sentence right here, seller agrees to execute any additional documents, if necessary, at seller's expense to complete the transfer. So if the seller agrees to sell this thing, and you pretty much get it right in these blank spaces here, even if you don't get it perfect, the seller's got to, if the seller does have to execute additional documents to make that transfer happen, they're under an obligation to do so. All right. So that's the additional provisions addendum. So we knocked that one out. We got one form out of the way. If you're keeping track on your scorecard at home, the additional provisions addendum, we've covered that. You're good. You got that forms change right down. All right. Moving back to 2T, we have a technical change here, but as far as the functionality of it, it's still the same. So I'm going to keep on scrolling. Right here, another technical change. Really, this was just to make sure that if your client gets bad check, they got a lot of remedies at law, and it's not just attorney's fees and court costs, which is what used to be here. Any of you who've had to deal with that know that you can get fines, you can get extra damages, you can get bank fees. There's all sorts of stuff. And there's a particular process for that that's spelled out in the statute. So if you get a client with bad check, then you're going to want to advise them to go see a lawyer to be advised about those particular remedies if they want to exercise them. But this was just to make sure that maybe some judge somewhere didn't say, well, this is all you're entitled to, and you're not entitled to the dishonored funds statute. This note just got moved, so we're going to skip beyond that. It's the same note that was there before, it just got moved down to the bottom. This is also another technical change, but just a note on this. This was my first go around through the form cycle on my own, and a lot of my focus over however long I do this, next few years or longer, decades. I don't even know how long I'll be doing this. Thinking of decades kind of scares me, but you know how it goes. Like, you just get started with something, and the next thing you know, you blink and it's been 10 years. Anyway, all it is to say is that my focus will be on trying to simplify things as much as possible. This is one of those edits. The earnest money is just going to be dispersed as it's outlined in the contract. There's many different ways the earnest money can be dispersed depending on what is happening with the contract. This sentence that's here highlighted is actually already at the end of the contract. However, it is such a common question that it's now up here as well. I don't know if we'll decide to delete the last one, this coming form cycle, or not. For right now, it's in here twice. And the reason it's in here twice is because one of the things that my law firm does is man the legal hotline for NC Realtors. So if you call the legal hotline, it's going to ring to our office. You talk to me or one of my partners, usually same day. And one of the common questions we get on the hotline is the contract effective if the money has not been paid? The answer is yes. Yes. The effective date is always whenever the last one of the buyer seller signs, and then that signing is communicated, whether it can be verbal, it can be by text message, it can be by email, it can be by carrier pigeon. It doesn't matter. As long as your client signs and your client's the last one to sign, you communicate that to the other side. Your contract is now effective. It does not matter if the money is paid on time or not. And that is because the seller has this mechanism up here in this paragraph where they can make a demand for the money, and it's got to be paid in one banking day. And if it's not, then they'll have the right to terminate. And you can use form 355 to make that demand. If you don't use that form, it's a good simple form to use to just, demand the money. You don't have to write a nasty gram email to the other side. You can just send them the form. They'll satisfy the demand, and they'll do it. Client can terminate. And, if the seller wants to, even after termination, they can go after the buyer for their earnest money and due diligence fee if they really want to, because of the buyer's being a breach. Scrolling on down in Form 2T, we've added exercise equipment. Mostly, I don't know how it is out your way, but I think in most markets across the state, COVID really brought on people installing exercise equipment in their homes in a more permanent fashion. Those things are going to be included unless they are excluded. And if they are excluded, which hopefully you are careful about filling this out, including leased items, solar panels has been an issue lately. If you guys have solar panels, if that's common in your market, just make sure you're talking to your seller about whether they are leased or owned, and talking to the buyer. But the big risk is with the seller, because this contract says the seller is going to deliver these things clear of any liens. Unless your seller wants to clear out that lien on the solar panels before they deliver title, then you need to make sure you're excluding those solar panels under this paragraph up here. In any event, if, say, there is some exercise equipment in the home, it's installed, it's attached to the wall, pulling it out is going to create a huge scar on the wall. What this says is that the seller must repair any damage caused by removal of excluded items, including exercise equipment, which was just added, in a good and workmanlike manner. Seller will notify buyer upon completion. However, this note down here says that if you got a pickety buyer who really wants to, this has to be perfect, it's going to be done this way, blah, 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 then they better fill out the additional provisions addendum on how those repairs should be made. And that paragraph is already in there. It's been in there. And I think it's a little bit underutilized by agents. It might be hard to do, in a seller's market, just because, there's so many buyers compared to the number of sellers. But if you can get any repairs in the additional provisions addendum at the front end of the contract, that's a whole lot better than trying to get it under a due diligence repair request, which the seller has no obligation to sign. And if you get them at the beginning, though, seller's already signed. He's got to do them. So, it's an effective way to make sure that the seller is going to make the repairs that the client wants. But sometimes I know it's hard to get it on the front end, but if you see something, you can get it in there. It's a good way to do it and look out for your client. We're going to get more into this later, but this here has been added to the buyer's due diligence process, and just to remind them to look for governmental compliance when they're doing their due diligence. We'll talk about that more, coming up when we get to paragraph 8H. Moving on down. This here, it's an additional warning that wasn't in here before. If your seller doesn't want to give the lead-based paint warning, then they need to understand that the buyer may be able to terminate right up until closing and get their money back. It's not something to mess around with. It's already there under federal law. And so it's not something that comes up very often, but it is a significant risk for you guys, both, especially on the seller side or listing side. But with buyer agents as well, it can be too if you failed to look at it. So just understand that that's there. That's here to protect you guys, and to make sure if you have that issue come up that you can point to that and be like, hey, no, we've told you, man. As I mentioned before, when we went through the additional provisions addendum, here's some check boxes about leases. Just make sure you get that correct. And then if you do, make sure that you're filling out either the additional provisions addendum or the vacation rental addendum. We're going to go over the vacation rental addendum in a minute. I'm not sure how many vacation rentals you guys have down there, but there is a change with that you're probably going to want to know about. So moving on down to paragraph 8G, what we have here is it's a technical change, but something that I hope will make transactions a little bit smoother. With respect to title, now this is a title issue, but paragraph 8G is talking about good title, legal access, meaning that the seller is going to provide fee simple, marketable, insurable title and access to the property, right? It's always been that way. Every once in a while, though, you'll have a seller or a buyer who tries to make, a big deal about some kind of encroachment or something like that. However, it needs to be now, if it's something like that, it needs to be a material, title issue, if that makes sense. I actually wrote a Q&A a couple of weeks ago about paragraph 8H, which we're coming up to down here. And I talk about the definition of material. Material means it's got to be significant. It's got to be something that's going to affect someone's decision making. Okay. And mind you, so this material term doesn't talk about lis pendens, monetary liens and judgments. Those still got to be free and clear. This has to do with other encumbrances or defects that buyers used to use to try and make a mountain out of a molehill with respect to the property and maybe try and weasel out of the transaction toward the end. It's got to be material. It's got to be significant. It's got to be something that is, someone that would affect their decision-making ability, not a 6-inch encroachment of the neighbor's fence post. Okay. That's not gonna fly. Down here in paragraph 8H, this is a brand new paragraph, and I want to talk a little bit about how this got added. There's been a lot of feedback with the addition of this paragraph, which is perfectly fine. Let me talk a little bit about how these forms are actually changed. Like, how do these changes get in front of you? There are two bodies that on this form, which is a joint form, there are two bodies that all these changes have to go through. One is the forms committee. Some of you may know people who serve on the forms committee. There are definitely people that serve out your way. There might be even somebody on this call. I don't know. I can't see who's here. In any event, the forms committee is made up of realtors. There's probably 20, 25 realtors plus an attorney from the real estate commission. I'm on there, but I am just a facilitator. So I don't vote. I don't do anything except try to, when the forms committee gives me feedback on a change they'd like or an issue they're seeing, to suggest language and things to address those. I don't decide whether it actually ends up in the form or not as a change. So that's one committee. The second one is the Joint Forms Task Force, which is made up of several members of the Forms Committee, as well as several members of the NC Bar Association real property section. So we're not talking about guys going out there like practicing criminal law and then coming and making changes to forms that affect real estate transactions. We're talking about lawyers that you guys work with day in, day out on closings. They are in this industry and see a lot of issues. So where did this come from? The Joint Forms Task Force, which is also, that committee is probably more like 15 people or so. But Joint Forms and the Forms Committee approved this change because what was happening is the buyer was often put in a bad position in the transaction, especially later in the transaction, if a governmental compliance issue was discovered. Because probably the most common one you're going to run into is permitting, okay? It'd be a permitting issue of some kind, and the buyer would discover it during the course of the transaction, either before or after the due diligence period, and then would be in a position of having to decide whether to accept the property with this permitting issue, which, depending on the permitting issue, can also be a tax issue because most taxing authorities can go back up to 3-5 years, and impose taxes that were not collected against the property owner that the previous owner would have technically owed, right? So it wasn't really these sorts of situations were not covered under title. The seller had no problem delivering good title. It's just that the title came along with this, this noose around your neck with respect to this permitting issue. So the buyer be in this position where they have to decide to close and accept it or terminate and, hope that they could get some kind of litigation attorney to get their money back. Which honestly, I think that they had a difficult argument to do so, especially if they closed, because paragraph 4H is still in here. If you close, you're accepting the property as is. That's always going to be a pretty significant hurdle for a buyer to get over if they want to try and go after a seller after closing. In any event, this governmental compliance provision was added to try and sort of equal the playing field with respect to these governmental compliance issues that come up. And there's really two safeguards built in so that buyers can't abuse this, okay? Number one is that it's got to be a material violation. So and there's that word again, and it's in my Q&A. And from a couple of weeks ago, it's got to be significant. It's got to be something that's going to actually affect the buyer's decision. Part of the discussion in Forms Committee was, what if it's, a jurisdiction that technically you would need a permit to install a new ceiling fan and that was not obtained? Is that going to affect it? No, I don't think that's going to trigger this paragraph. No, I don't think anybody I've spoken to reasonably believes that that's going to trigger this paragraph. So if it's a small permitting issue like that, doesn't really affect anything, then this paragraph's not going to apply. But I just got a question this week where it was, an enclosed screen porch, no permits pulled, added a bunch of square footage because it was, you can either argue it's either other square footage or finished just based on including the screen porch. But, that's something that's material. That's going to be a big deal. A finished basement where no permits are pulled, that's a big deal. I mean, you're talking about tens of thousands of dollars usually to try and bring it within permitting compliance. Because once you put up the drywall and everything and finish it off with all this stuff, if you're going to go back and try and do the permitting after that, then you're talking about having to do significant damage to the property to get the permitting in place and then put it back together, right? So that was definitely happening. These were issues that were really coming up. So the first thing is it's got to be a material violation. And if it's a material violation, then we'll get into how the rest of this paragraph operates. But first, I want to talk about the second safeguard. So even if it's material, if the seller discloses the violation prior to the contract becoming effective, then the buyer's not going to have any access to this paragraph either, as far as remedies go. So, we're not going to cover Form 101 today, the exclusive right to sell listing agreement, mostly because it's really reflects the changes that in 2T. But there are two new paragraphs in there. One has to do with your client disclosing litigation concerning themselves, the HOA, or the property itself. So if there's any of that going on, your client needs to disclose it to you so you can make that disclosure. Another change in Form 101 in the exclusive right to sell listing agreement that you're going to want to make sure you pay attention to is this governmental compliance paragraph where your client needs to disclose to you if they've got one of these issues. And you're going to want to talk to them in depth about that, because if they make a disclosure about that, it's probably not going to affect the value of the property that much. People sell unpermitted space all the time. But what it is going to do is pull this paragraph from the remedies the buyer may have if something like this is discovered. So those are the two safeguards. Number one, material. Number two, the seller can disclose and avoid it. So what kind of things are covered? Sorry, there's one other thing I got to do before I get into that. The third thing you got to understand about this paragraph is that it is a condition of the contract. Condition meaning that it operates just like the condition of property at closing paragraph. If it's not satisfied, the buyer is going to be able to get their earnest money and due diligence fee back, but not their costs, not attorney's fees, not anything else. It's just going to be earnest money, due diligence fee at the end of the day if the buyer gets to have this remedy. Okay. All right. So things that are covered under this, they're all right here. The seller is making affirmation that is a condition of the contract, the property be conveyed free of any material violation of law, ordinance, permit, or government regulation, including, but not limited to, building, stormwater, impervious surface, environmental protection, and zoning. Impervious surface, for those of you that are familiar with stormwater fees, that's really what this is talking about. And I got a question this week. Somebody covered a deck. They put a huge old gazebo on the deck and put a nice little grill out there and everything. Well, guess what? You do that and you are increasing the impervious surface of your property, because that water can't filter down through the deck into the ground as it ordinarily would. Creates runoff, and the chances are the taxing authority where you live, especially if you're in a municipality, that means that your stormwater fees should reflect the amount of impervious surface you have on your property, including your driveway, roof, and things of that nature. When I was the mayor, we had an issue with not having enough money to address all the stormwater issues. We're having flooding in certain parts of the city. And so our staff went out and, were able to find out from software that we started using what properties had actually added impervious surface, which contributed to the stormwater problems we were having. And we're able to go and start charging them the appropriate amount of stormwater fees so we could actually fix the problems that were happening. I think that's going to become more and more common. And so that's why this is in here, and along with environmental protection, zoning, things like this. All right. So let's pretend that, the seller has not disclosed something. Let's say it's a permit violation. Let's say it's a finished basement, probably something that's relatively common in your transactions. It's a finished basement. It's not been permitted. It looks really nice. Let's pretend that the seller didn't skimp on this one. They really did a nice job with it. It's a nice basement. All right. This adds a lot of value and interest to the property. All right. So the seller doesn't disclose that. Property goes into contract, and the buyer discovers that this finished basement has not been permitted. The seller finally tells their agent discloses it because it's a material fact. All right. So if a violation is discovered after the effective date prior to closing, because this thing is not going to survive closing, okay, then seller may cure the violation. All right. So if it's possible for the seller to cure the violation, then they can just go ahead and do so. Buyer has no remedy. All right. But if the seller does not cure the violation, then the buyer may choose to accept the violation and close, or terminate this contract and receive the refund of the earnest money and due diligence fee. So that's how this paragraph operates. If you have a situation where you think it might be coming up, then, as I said, I already have had questions this week. These forms just came out July 1st, so these questions are already coming in. So far, it seems to be working as intended. It's probably going to take a little while for sellers to really and listing agents to really grasp how important it is to make sure this disclosure happens. But that's how, at least for right now, for this form cycle, the Joint Forms Task Force and the Forms Committee have chosen to address this particular problem. And they'll be monitoring it and I think discussing it again. I think we just got the agenda for the first meeting and they're going to be talking about it again. So I think you can expect some changes with this paragraph, but for right now, that's how it works and that's what we got. All right. So moving on down. And I'm sorry, I'm really, really sorry. You're just not going to like me. You're just not going to like me after today, I think. Well, maybe, well, I don't know. In any event, for this paragraph with who the deeds to be made out to, you got to quit filling this out. Generally speaking, more times than not, you are not going to fill this out. All right. And that's because, and I hate to tell you this, sometimes it's hard to be honest, but let's have an honest conversation. That honest conversation being, at least from the closing attorneys I've spoken to, you guys are filling this out wrong like 75% of the time. And the closing attorney is having to go and do their own thing anyway to make sure that they are getting the deed made out correctly. Okay. It is more of a lawyer issue anyway. It's unfair, in my view. It was unfair to expect you guys to get this correct in the first place, especially at the beginning of a contract. Sorry, you guys do a really, really good job of going in with, just a little bit of information and really getting it mostly correct, even with a little bit of information you have. So I will give you kudos for that all day long. That's not an easy thing to do at all. It's a difficult part of what you guys do. So this is really meant to help you, especially later in the transaction, if it turns out that you're not going to be making it to whoever you put in here in the first place. Sometimes you get a difficult seller who thinks that they have to agree to such a thing. Sometimes you get, somebody who's, whatever. Mostly a difficult seller. There might be other situations too, but in any event, let's go through this list here because that'll tell you when you might. There's still a blank here. You might, in rare occasions, still fill this out. Only rarely, though. So the deed can be made to the buyer. So whoever you put in the top, line there on the paragraph, page 1, top of the first page, whoever's in that buyer line, it can be made to buyer. Okay, whoever's in there. Or number 2, a corporation, LLC, or other business entity of which buyer is sole owner or shareholder. 3, a trust where the buyer's a beneficiary. 4, any relative of the buyer. So you got to add mom because of the lender, or mom and dad, or whatever, brother, sister, any relative, deed can be made out to them. You don't need to make any changes at all. And then finally, and we've already changed this error. I apologize. 1, 2, 3, 4 E. I don't know. We're just not perfect over here. We do the best we can. Anyway, it's already been fixed. It should be correct in the forms that you are using now. But these are the way that we release these. We have to release the summary of the forms changes before we do the final proofing. So we try and get it as accurate as we can, but every once in a while, Anyway, so if you don't, so let's say it's like a boyfriend, girlfriend, girlfriend situation, something like that. They want to buy a house together, which frankly, in any of those scenarios is a really dumb idea, but let's say they want to do it anyway. Then you would insert the names then. They're not related and, the other 4 don't apply. That's something where you're going to put the names in. Okay. Other than that, make sure you insert the names only. To be determined, NA, all this other stuff that was frequently getting put into these blanks. Do not put anything in there. It must be names. And if you have any question about what names go in there, then you should probably be directing those questions to a closing attorney. All right. Moving on down in Form 2T. I'm going to skip that one. I'm going to skip that one too, just based on time today. And as I said, this is a repeat here of what's in the effective date paragraph. So I think that's it for this form. All right. That is Form 2T. This was the additional provisions addendum. We went through that. I'll just note here that with respect to leases, remember those check boxes for whether the property does or does not have a lease in Form 2T. The seller needs to deliver an assignment. Seller authorizes all these people to give information. And then all means of access to the property other than those in tenant's possession must be delivered at closing. It was just really cleanup work as far as this paragraph was concerned to make sure that those things were done by the seller. there's two new guidelines that came out this form cycle. I'm not going to go over them. I just want to note them. I wrote these and then they were approved by the committees. I really tried to make sure for the buyer possession and seller possession, both. Those are the two new guidelines that I really talked about things that are not in the form itself. For example, paragraph 1 here, when do you use the seller possession form as opposed to, say, an actual lease like 410? You know, it talks about that in here, and about sorts of rules of thumb. Down here in the paragraph 5, it gives I think, a very good, succinct overview of what the eviction process is, which hopefully you don't need that, but every once in a while you do. So that's what these forms or guidelines are for. Make sure you are looking at those if you need to, going over them with your client if you need to. On the seller possession addendum, and there's also some similar changes in the buyer possession addendum, so I'm not going to go over both. I'm just going to go over the seller possession. Number 1, there's a new checkbox choice up here at the top where the seller can remain in possession until a date certain. So you put that in here, or for a blank number of days after closing, if closing is sort of a moving target and the seller just wants 2 weeks after whenever the closing happens. This is cleanup. It's basically the same. The seller is going to exclude items that they don't want to maintain. They otherwise have to maintain the property. This was cleanup to make this harmonize better with this indemnity paragraph down here, which the guidelines actually talk about a little bit. If you're a total nerd and you really want to nerd out on forms, you can go read about that and get a little mini law school education on that particular issue. Paragraph 4 was cleaned up in response to actually a WRAL article that came out a couple of years ago where the seller was trying to make the argument that as long as they paid this holdover fee down here, they could just stay in the property. Yeah, no. That fee is to compensate you for being a breach. It is not for you to just stay as long as you're paying it. So this language has been clarified to make sure that if the seller overstays or if the buyer overstays in the other form, that they are going to be they're subject to eviction. Here, removal of seller's property, just making sure this is beefed up a little bit. The seller removed garbage, debris, as well as seller's personal property that wasn't part of the purchase. Okay. All right, moving on. Vacation rental addendum. For those of you that do vacation rentals, there's a note here about VRBO and Airbnb. It's mostly for your clients if you want to cover it with them. Down here is the part that I really want to cover for today. If you do a vacation rental, or if you're buying one, you may encounter this with folks that maybe you're reviewing stuff from the coast, maybe you operate multiple markets, things like that. In any event, it was a common issue out at the coast where the buyer and the seller would have sort of this verbal side agreement about the property management firm. And of course, what would happen is they would have this verbal side agreement and the seller would go under contract thinking, okay, this buyer's going to take over my property manager, so I don't have to pay all these early termination fees. Well, guess what? The buyer would change their mind, and is it really enforceable? No, it's not. And the goal of this is not to force the buyer to go with a certain property management firm. Rather, what this is it's an agreement between the buyer and seller that the buyer's going to, they can hire whoever they want, but if they don't hire the sellers, then there's going to be a credit at closing of X dollars. If you're on the listing agent side, you're going to want this number to be as close to the early termination penalties the seller's going to face if the property management firm, finds them in violation. Okay. And maybe there's an agreement you can work out with the property management firm to limit those fees or things of that nature. On the buyer side, you're probably going to want that number to be as close as to 0 as possible. Or NA or whatever. It just not applies. In any event, it's a negotiated amount. It doesn't need to be exactly any of those things. Those are just kind of rules of thumb about what number you might put in there. And that's the reason that this was added. All right. Moving next to a brand new form. You'll see no highlighting on this because it is brand new. Well, I guess highlighting on the new form number. This is an agreement for sale of personal property, I am going to be working on Form 2T this form cycle to eliminate personal property from that form, because we now have this form, which I think lenders are going to vastly prefer. And that's because you guys are not going to attach this new personal property form to the contract. Everybody say, everybody raise your hand, say, we will not attach this as an addendum to the contract. Lenders do not want to see this. They don't care. They want it to be as far away from them as possible. They've always wanted it that way. So you guys finally have the tools available to make that happen. I hope they appreciate that. I hope they appreciate the amount of time, effort, and energy that we put into making them happy. They don't. No, it's sort of like them being married, probably. But anyway, personal property. If you got personal property in the transaction, then you got you can fill out buyer, seller, real property. The interesting thing about this form is that it can or cannot be contingent on whether the real property closes or not. So, and that's this checkbox right here. If your seller just wants to straight up sell the personal property, then you would put is not. This agreement is not contingent on the seller and buyer closing on the property. You want the couches or lawnmower or whatever, refrigerator, yeah, I'll sell it to you straight up, or we'll sell it for this amount of money that's up here, and we'll just sell it straight up. But if your seller's like, no, I'm not getting rid of all the furniture, unless they're also buying the real property, then you're going to check is. And you're going to say, all right, this agreement is contingent. So this agreement's only going to spring into effect if there's a closing of the real property. And then, it'll be binding at that point. Right here are blanks to insert, what property is being conveyed. If it's a lot, then probably what you want to do is put C attached and then attach a piece of paper to it just with the items, and that's perfectly fine. Here's some disclaimers. Basically, this is all lawyer mumbo jumbo to make sure that the buyer's taking this stuff as is, and they're not really going to have the ability to come after the seller for anything wrong with that personal property like you would anything else. And that's pretty much it. They sign at the bottom. Tried really hard to keep this at one page so that it's nice and simple for you guys to use. Again, I will repeat, do not attach this to the Form 2T. This is a completely separate agreement. All right. Moving on. We're going to talk about some new terminations that are available to you guys. Notice here that number one, this note has been, what's been eliminated here is the word right. Unilateral right? No. These are now just unilateral terminations, because here was the problem. And this was also the same in Form 2T with respect to 8H. You guys were, at least in my experience, and especially with real estate firms that we were representing in my office, there were significant risk management issues with some of these things, like an unfinished basement, for example, and that wasn't permitted. There'd be pointing fingers. A party who feels aggrieved, they're going to go get a lawyer and do whatever they got to do to try and make themselves whole. So, these things are with a focus of making sure that to the extent possible, we're limiting your guys' risks. I talk about that with respect to 8H in my Q&A. I'll leave that there. You can go read that Q&A to figure out that. But this is also the same thing, because what was happening is, say the buyer would want to terminate, which this is Form 350. So we're going to go through the buyer, but understand that similar check boxes are with the vacant land termination forms as well as on the seller forms. So the new ones are there, except for this one here. These two have been added to the other forms. And it benefits nobody, and it especially does not benefit you guys as brokers. To have whether the property is under contract question in limbo. It's not good for listing agent. It's not good for the buyer. It's not good for the parties. It's not good for anybody. So what these check boxes are meant to do is give clarity and certainty to hey, I am terminating. This is over. Okay. Whether, none of these check boxes add rights to what the parties already had. Okay, none. No rights being added at all. These are boxes are just to facilitate things that your clients were already doing. It is not your guys' fault that these are added. This is definitely your client's fault, no doubt, in my mind at all. I'm being serious on that. Sorry. And the laughter was not meant to indicate I wasn't being serious, but I'm dead serious. This is your client's fault. If they didn't do the things that they do, you guys wouldn't be put in the positions that you're in. In any event, new checkbox here in Form 350 for the governmental compliance. So if that condition is not met, then you can check that box and send it over. These last two, the buyer can give notice and either allege that there's been a breach of the contract. That doesn't mean there's been a breach. The seller doesn't need to agree to that. All this is doing is saving you guys from sending an email, making these sorts of allegations, to the listing agent. Let it come from your client. That doesn't need to come from you. That's an assertion of a potential legal right anyway. It's something you guys get pulled into sometimes because of the nature of what you're doing. You are negotiating contracts. You're trying to facilitate this transaction. It is, in the ways that you are totally entitled to do by law. You are acting in dealing with some legal issues, right? You're not lawyers, but they're there. I mean, you guys have to navigate these questions and issues. But some things, though, it's just better if you can realize that this is not your arena and it's time to move on and let a lawyer take over. And this is one of those situations. So the buyer can give notice, say after, it could be after the due diligence period, it could be during, but they can terminate and say, you've breached the contract. And if they check this box during the due diligence period, then they should get a refund of the earnest money anyway. It's really just a question of, now that there's been an allegation of the breach, does the seller agree? Does the seller disagree? Can they work it out? And they can work that out later on their own terms, but at least, and you can still use Form 390. If the seller agrees to give the due diligence feedback, he's willing to sign that, you can use Form 390, which is the mutual agreement to terminate. If you cannot get agreement on that, then you can check this, your client saying, no, you breached the contract. And they'll forecast that they're also seeking their due diligence feedback as well. And then finally, you've got this checkbox here where the buyer is just terminating. They're just done. They're over. They're not moving forward, and they're not providing a reason at all. Both of these come with an advisory to your client to protect you. They are strongly encouraged to seek legal counsel before checking this box and signing. So, all right, those are the new check boxes there. Of course, you have any questions on that, the legal hotline is available from NC Realtors. I can drop that information in the comments if you don't have it already. It should be on the website too. But the email is legalhotline@ncrealtors.org. Phone number is the main office in Greensboro, and they'll transfer you over. All right, we're winding down. We got two small changes left here. All right. This one here, this is the agency agreement and renewal. Okay. So if you are doing an agency agreement or renewal, this language has been added just to make clear that if you sign one of these with your client, that previous amendment is going to be binding unless it's superseded by this one. So let's say you fill out the price on the first one. You do an amendment of these, you change the price. Then a few weeks later, you want to change something else, maybe it's the kind of marketing that you're doing. Well, the previous price change is still going to be effective, okay? But now let's say you change the price, and then a couple of weeks later, you change the price again. Well, that second one is going to supersede the first, okay? And this language here is just to make sure that as a default, previous amendments are going to continue to be effective unless they are changed with a subsequent amendment. And then finally, on the referral agreement, this is something where I'm going to have to clean up this second box here. I don't think that's been done yet, but it's on my list of things to do this week. In any event, the intent of these changes is that if the client buys or sells more than one property prior to the end date, then you get paid on both if you are the referring firm. Okay. Now, if you don't want that, then fill out, check box this other, and then write in whatever it is that you want. Okay. But otherwise, if you're choosing one of these two up here, the default is you're going to get paid on each transaction, if there's more than one. All right. I'm going to stop sharing my screen for right now so I can see a little bit better. Looks like we have some questions. So I'm going to go to those. All right. So first question is, are these available in the JCAR forms area as well? The ones with highlighted areas? I'm not sure on that. That's a question for Bonnie. You can definitely get it on ncrealtors.org, which is, that I which I showed at the beginning. Go to the legal Q&As section of the website and you'll be able to find it pretty quickly there. And will this be available to watch again? Again, that's a question for Bonnie. I'll let her answer that. My guess is, well, actually, no, I can actually answer. If you are part of the NC Realtors Facebook group, I basically gave this same presentation on Monday this past week, and I know that that you can watch it there. So I don't know if Bonnie can answer whether it'll be available here.
Yes, I am recording today. And then also on the first question, I believe everybody has availability to the forms, and as long as you're a member of JCAR, they'll have access to them. And then, John, I have one question that came up in the comments. What happens if an old or past permits cannot be confirmed due to poor record keeping by some counties?
Well, that's something where, the burden is going to be on the buyer to show that. The seller, they're making that affirmation. If the buyer doesn't think that that's happening, then, that's going to be their burden. I think this issue that you're bringing up is definitely going to be something the forms committee is going to look at to try and make some clarity in this paragraph on these sorts of issues where, the ability to confirm the ability to confirm the permit is impossible, just due to the nature of whatever. So, I think that's a good question. And if they can't be permitted, then, the seller's making affirmation. And otherwise, like I had a question this week, and this will be something that, it depends how much digging you really want to do. But this week I had, somebody talking to me about how the third floor of a home was not permitted. Well, that doesn't make sense. Was the third floor added after the CO? If the house got a CO, then the thing is permitted. So there's issues like that, allegations like that are not going to square. There's certain of these things that are going to be able to be figured out. But at the end of the day, you just have to understand, if the parties want to get, down and dirty about it, then they need to go get lawyers and fight about it in court. That's the appropriate place to go. No, we're not going over the RPODs today. The RPODs is that form comes from the real estate. Sorry, can you hear me? Okay, I think I'm good. No, we're not going over the RPODs today. That's from the Real Estate Commission. That's their form. I will note, however, that they are currently on a comment period. If you go to ncrec.gov, right there on the first page, you can go see what they're proposing for the RPODs, which it's a pretty extensive change. It's going from 4 pages to 8. Some of that is just breaking up the spacing a little bit. Some of it is substantive changes. So you may want to go there and look at that and give input. My law firm gave some input this week on that form. So I'm not going over changes to the RPODs because those changes, don't come from us. Plus, they're not even done yet. You have time to put input on those changes if you want to. There's another question here that I'll answer real quick. Is there a form that the seller can sign if the buyer refuses to sign a termination but verbally does not want to close, the contract expires? Yes. As I said, the seller had similar check boxes on their termination forms too now, where the seller can send a termination. Also the same thing, that they should talk to a lawyer first before they do that. And for the seller, that's going to be an especially important warning because, as all of you know, the seller faces a pretty good claim of specific performance. They can't just willy-nilly terminate. They have very limited right to terminate under the contract. So more times than not, if they're trying to terminate under the contract, they're going to be looking at breach and potentially facing a claim for specific performance from the buyer. All right. I think that's all the questions.
All right. Great, John. Thank you so much. We appreciate your time. And I'm sure you're going to be getting plenty of calls and emails because of all this. And so I don't envy you in the next few months.
Nah, it's fine by me. My view on it is this: is that changes are not fun. I don't really like changes either. But I think if you think about it this way, these were all problems you were likely having anyway. All we're trying to do is give you some better tools to deal with those same problems. And once people get used to them, then we'll be able to get feedback and improve it even more. And that's what we're here for.
Right. Well, we really appreciate your time today, and thank you for enlightening us on the form changes. And I'm really grateful that we have somebody like yourself there helping us out.
Appreciate being here. You guys have an excellent day.
Thank you. So also, if you guys will look in the chat box, you can see that there's been a link put in there to access the new disclosure and information on that. So if you'd like to get more information about that disclosure. So we do have a couple announcements before we end today. We have our affiliate fair coming up August 17th from 11 to 2. If you haven't ever attended that, there's going to be vendors there. There's going to be some tech questions. There's going to be all sorts of different things happening. It will be at the Clayton Center. I believe that's correct. If not, you can go on our Johnson County Association of Realtors website and take a look at that for August 17th. We also have August 22nd, a lunch and learn with Ryan Zaney, who is navigating the home inspection. So that's really good information to know about that. Also, we'll be having our JCAR golf tournament September 27th. I hope you guys will plan to attend. If not, if you'd like to sponsor a team, if you don't play golf like me, I'm not a good golfer. If you like to just sponsor a team, it's a lot of fun, a lot of prizes, a lot of ways of meeting a lot of different folks out there in our marketplace. So I encourage you to get involved in that. We also have our new JCAR podcast, and we have recently just released our most recent podcast with Matt Fowler. So please enjoy that. And anyway, we have got lots of things happening. I know you guys are in vacation, but we're getting ready to start up our next challenging market that's coming up here with the marketplace and such. So I do encourage everyone to be working on your basics of your business, which would include how to get those spheres of influence involved in your business every day and reaching out to your client base. But thank you again for joining us today. I think it was very informative, and I'd like to thank you all for being here, and have a wonderful, wonderful day. Thank you so much. Bye-bye now.